imposed, the right to approach the court, the right to the writ of habeas corpus cannot be suspended. This right will remain. So he was directed to be produced before the court. His detention was found to be unsustainable, set aside. Against this, ADM Jabalpur filed moved the Supreme Court. And this is the famous case of ADM Jabalpur versus Shukla. In that case, 5 judges. The case was heard by 5 judges. In a 4:1 verdict, Supreme Court said when emergency is declared, you do not have any locus standi. You understand locus standi? Right to approach the court. You do not have the locus standi to seek a writ of habeas corpus. Your right to seek judicial remedy stands suspended. So the judgment of the Madhya Pradesh High Court was overturned. 4 judges included Justice Y. Chatterjee, the father of our present Chief Justice of India. The only dissenting judge was Justice H.R. Khanna. He said that fundamental rights like Article 21 existed in us. It is not that our Constitution has given this right to us. By virtue of being a human being, we have this right to live like a human being. You take away 21, we don't live like a human being. So therefore, when we say we are human beings, this right, Article 21, is inherent in us. He was the lone dissenting judge. Well, this is the famous case of ADM Jabalpur versus Shukla, 1976. Then, of course, the emergency was lifted, elections were held, political developments took place. We are not concerned with that. Indira Gandhi's daughter-in-law, Maneka Gandhi, after the election results were declared, she wanted to travel abroad. But her passport was impounded. Okay. Impound, you know, seized by the passport authority. She challenged this on the ground that right to travel, including right to travel abroad, is a part of Article 21 of the Constitution of India. Without giving me an opportunity of hearing, you cannot impound my passport. So this is the famous case of Maneka Gandhi versus Union of India, 1978. For many, many reasons, this is considered to be a watershed in India's constitutional history. R.C. Cooper, the bank nationalization case, we have seen, partly it had overruled A.K. Gopal by holding that 14, 19, 21 can be read and interpreted together. In Maneka Gandhi's case, Supreme Court said that there must not only be a law, the law must not only prescribe a procedure, but the procedure prescribed must be fair, just and reasonable. Therefore, principles of natural justice would have to be read into this procedure. In A.K. Gopalan, the view taken was that there must be a valid law and that law must prescribe a procedure. Once the law is there and the procedure prescribes and the procedure is there, your right, life, liberty can be taken, abridged. This was the view in A.K. Gopal. Maneka, this is a complete somersault that it is not only that there must be a law, there must be a procedure, but that procedure must be fair, just and reasonable. Principles of natural justice would have to be read into it. 1950 was A.K. Gopalan, 1970 was R.C. Cooper, 1978 is Maneka Gandhi. So it took almost 3 decades, 30 years to overrule the decision in Maneka Gandhi. It is often said that the majority opinion, that is the binding law, that is the law of the land. But it is the minority where the wisdom lies. Today's minority view